rare week of good news for immigrants. For once, the headlines in U.S. immigration aren't about crackdowns or restrictions. They're about accountability, fairness, and hope. This week, two groundbreaking court rulings have delivered long-awaited justice and relief to immigrants across America. In New York, a federal jury awarded $112 million in damages to hundreds of immigrants who were illegally detained under ICE detainers. And in Washington, D.C., another federal court blocked USCIS from enforcing its controversial $100 asylum application fee, calling it unfair and poorly implemented. Together, these victories mark a powerful moment of judicial oversight and constitutional correction, reminding everyone, from federal agencies to local counties, that immigration enforcement must still respect basic human rights and due process. Part 1. The $112 million verdict, a landmark win for justice. In one of the most significant immigration rulings in recent history, a federal court in New York ordered Suffolk County, Long Island, to pay $112 million in damages to immigrants who were unlawfully detained between 2016 and 2018. Here's what happened. After finishing their sentences, or even after their charges were dismissed, 674 immigrants were kept in custody simply because ICE requested local jails to hold them for pickup. But those ICE detainer requests were not judicial warrants. They were just administrative forms, lacking any judge's signature or probable cause review. The court ruled that these extended detentions violated the Fourth Amendment, which protects against unlawful arrest or seizure without legal authorization. The message from the federal jury was crystal clear. Local governments cannot treat ICE requests as lawful warrants. This case is not just about money. It's about the limits of local power in federal immigration enforcement. The decision reaffirmed that no local official can detain someone beyond their release date unless a court order or warrant explicitly authorizes it. Part 2. Who represented the immigrants? The plaintiffs, hundreds of affected immigrants, were represented by two major advocacy groups: Winston & Strawn LLP, a respected national law firm; Latino Justice Pro-Def, a civil rights organization focused on protecting immigrant communities. They argued that these individuals were held without probable cause or judicial review, often for days or weeks, even after their criminal cases were resolved. The jury agreed. They ruled that these detentions were unconstitutional and reckless, imposing a massive $112 million penalty on the county to reflect the severity of the violations. This verdict wasn't just symbolic, it was historic. It reminded local officials across the United States that cooperating with federal immigration enforcement doesn't mean abandoning constitutional safeguards. Part 3. The legal ripple effect nationwide. Although this lawsuit originated in Suffolk County, its impact reaches far beyond New York. Across the U.S., many local jails and sheriff's offices still honor ICE detainers automatically to avoid friction with federal authorities. But after this ruling, that practice could cost them dearly. The court's message was simple. Holding immigrants past their release date without a warrant or judge's order is a violation of constitutional rights. Local agencies that comply blindly with ICE detainers risk massive civil penalties and lawsuits. As a result, counties and municipalities nationwide are now expected to re-examine their detention policies. Many may start requiring stricter legal reviews before holding anyone on ICE's request to prevent unlawful arrests and protect themselves from future litigation. This decision sets a new national precedent, reinforcing that the Constitution applies equally to citizens and non-citizens alike. Part 4. A deeper constitutional debate. This ruling fits into a much broader legal discussion that has been unfolding for years. How far can local governments go in helping enforce federal immigration laws? Federal courts have long maintained that ICE detainers are voluntary, not mandatory. That means local jails are not legally required to hold anyone just because ICE asks them to. In fact, multiple federal courts have repeatedly found that doing so without judicial authorization amounts to an unlawful seizure, a direct violation of the Fourth Amendment. Organizations like the ACLU and the National Immigration Law Center have long warned that such cooperation exposes local governments to serious legal and financial risk. And in some states, local laws go even further. explicitly prohibiting local police or sheriffs from detaining anyone on ICE's behalf unless a judge signs a warrant. The Suffolk County ruling, therefore, does more than compensate victims. It solidifies national precedent and ensures that immigration enforcement must respect both local autonomy and constitutional limits. Part 5. A turning point for local-federal cooperation. This case has effectively redrawn the line between federal immigration authority and local law enforcement power. It serves as a reminder that even when local governments cooperate with ICE, they cannot act outside constitutional standards. The ruling also encourages other jurisdictions to review detention practices and implement stronger legal oversight mechanisms. Legal experts believe this verdict will inspire similar lawsuits in other states, ensuring consistent enforcement of due process protections nationwide. At its core, this case represents a structural correction, a reset for how immigration enforcement works at the ground level. Part 6. USCIS blocked. $100 asylum fee suspended. Now, let's move to the second major decision of the week, another big win for fairness. In a separate case, a federal court has temporarily suspended the USCIS $100 asylum application fee, which was introduced earlier in 2025. USCIS claimed the fee would help cover operational costs and reduce backlogs. But advocacy groups argued that the rollout was confusing, poorly planned, and lacked proper legal notice. Several lawsuits were filed, accusing the agency of failing to follow required administrative procedures before imposing the new charge. After reviewing the case, the court agreed, finding that USCIS had not provided sufficient notice or clear implementation guidelines. The judge ordered the agency to suspend fee collection immediately until further review. Part 7. What this means for asylum applicants. This ruling brings immediate relief to thousands of asylum seekers who were struggling to afford yet another fee in an already complicated process. Here's what you need to know. Applicants who haven't paid yet don't need to pay the $100 fee. Those who already paid will not get a refund, but future payments are paused until new instructions are released. The court's decision forces USCIS to rethink how it implements new policies, ensuring transparency and proper communication before introducing additional financial requirements. Legal analysts say this could spark a broader review of how USCIS rolls out new regulations, particularly those that impose financial or procedural burdens on immigrants. It's also a strong reminder that immigration fees must comply with federal administrative law and be introduced fairly and transparently, not rushed into effect without public notice. Part 8. Judicial oversight restoring balance. When you look at these two rulings together, a clear message emerges. The judiciary remains the strongest safeguard for immigrant rights in America. The Suffolk County case reaffirmed the constitutional protection against unlawful detention, while the USCIS decision emphasized the importance of procedural fairness and accountability. Both rulings show that justice for immigrants doesn't only come from new laws or Congress, it also comes from the courts enforcing existing constitutional principles. In an era where immigration enforcement often expands faster than oversight, these decisions act as a check and balance, ensuring federal agencies operate within legal limits. Part 9. Implications for policymakers and communities. For local officials, lawyers, and policymakers, the takeaway is clear. Every immigration action, whether it's a detention or a new fee, must respect both constitutional rights and federal law. Federal requests don't override due process, and administrative shortcuts will face judicial correction. For immigrant communities, these rulings bring renewed confidence that the system can still deliver fairness when pushed to its limits. It's also a reminder that collective action and legal advocacy work. The plaintiffs, lawyers, and civil rights groups who brought these cases forward have now set nationwide precedents. Part 10. DV 2027 Diversity Visa Program Update. Before we wrap up, let's touch on one more important update. As of today, the registration for the DV 2027 Diversity Visa Lottery has not yet opened. The U.S. Department of State has confirmed that no official announcement or start date has been published. When it does open, the only official platform will be dvprogram.state.gov. And remember, participation is completely free. Be extremely cautious of fake websites or agents offering priority access or guaranteed selection in exchange for money. These are scams not recognized by the U.S. government. To prepare, make sure you have a valid passport, a recent passport-size photo that meets official specifications, correct personal and contact information. Once open, the entry period usually lasts around 1 month, so timely preparation is key. Final thoughts. This week's developments show that change doesn't always come from Washington. Sometimes it comes from the courtroom. Immigrants across America just saw two major victories. One reaffirming constitutional rights and limiting unlawful detentions. Another protecting asylum seekers from unfair financial burdens. Together, they mark a hopeful moment in U.S. immigration law, a reminder that the system, when challenged, can still protect fairness and accountability. If you found this update valuable, make sure to like, subscribe, and turn on notifications so you don't miss future immigration reports here on USA Alert Zone. Until next time, stay informed and stay hopeful, because change is happening.